While the world remained busy talking about the immigration level plans, the quota, the prospective Tier 2 PR and whatnot, immigration refugee protection regulations have been quietly updated. Two specific updates are really shocking to me, to say the least. 180.1 subdivision D says that an immigration official has now the power, if the officer believes on a reasonable ground to believe principle, that a work permit, let's say a work permit has already been issued, but if the officer suddenly believes that, well, even though I have issued the work permit, I don't really believe now that the person would leave Canada at the end of the period authorized for his temporary stay. Just on his belief, he has now the power to cancel the already issued work permit. The shocking part about this is that the assessment criteria has made so subjective that reasonable grounds to believe, if I am an immigration official and if I certainly believe that Mr. X will not leave Canada, I now have the power to cancel the work permit already issued to Mr. X, regardless how lawful the person is, regardless whatever contribution that the person is making, right? That's one. The second one goes even further. Regulations 180 dot subsection 1 subdivision E says that if Mr. X, for example, applies for a new kind of visa or a permit while living in Canada, right? If the new permit gets rejected for whatever reason, that rejection can potentially trigger the cancellation of his or her existing permit. How shocking is that? Not kidding, these are the actual modifications that have taken place in the regulations. And therefore, I know PR is important. You all are thinking about the permanent residency and potentially citizenship and everything. But my request here is that concentrate on what you really have. Do not really think that if you are on a work permit, if you are on a visitor record or a restoration of status, TRP, etc., your status is secured. Forget about applying for those dummy work permits. If you are applying for a visitor record, be very serious. If you are applying for a restoration of status, get even more serious, because if any of those applications get rejected, by law, now your existing status could now be put into jeopardy. If you need our assistance with understanding this kind of complicated legal principles, more than welcome to hop into the website novonation.ca, book a relevant professional consultation. Happy to talk to you.